I move this motion and I want to thank you. Under Rule 59, 59B, 1B. And the motion, Mr. Speaker, is a motion of adjournment to discuss an urgent matter of public importance. So, Speaker, I want to thank you. You were generous in allowing us to make comments the way we did about the Supreme Court judgment. But because of the importance of this judgment, I am moving this motion, Mr. Speaker, to persuade you to adjourn the subject matter under consideration and to allow us at least an hour to discuss this matter. Why? The defeat in court was not a defeat just of the Attorney General. In fact, when Parliament was making this law, the Honorable Chiwanuka Chiriowa was not even the Attorney General. So this judgment also touches on how Parliament conducts business here. How you are advised, because the way the Chief Justice described setting up of the court martial, he said it's like asking him to go to Mulago to begin operating patients. That's what Parliament did. And any MP worth the name must take this as a very serious matter. That what we did, what Parliament did in setting up the General Court Martial was like telling a lawyer to go to Mulago to operate patients. And second, Mr. Speaker, the constitutional order in the country, this judgment touches on the constitutional order. That you have a military that has taken over management of society. The CDF is issuing one tweet after another. We are now asking Attorney General to advise him. So the motion, Mr. Speaker, of adjournment is to allow us to present these matters to the satisfaction of the public. The public now is very happy with the judiciary. It is time for the public to also be very happy with the Parliament, especially because it's this Parliament that established that General Court Martial. I am lucky I was not in that Parliament. Otherwise, the words of the Chief Justice. So that's the motion, Mr. Speaker, that I am moving to adjourn consideration of the matters on the floor now to discuss a matter of urgent public importance, and that's the judgment of the Supreme Court.
Thank you. Thank you, Honorable Ssemujju. No, wait, I guide before. I need to guide, okay? That's why I'm here. Now, this matter goes beyond Rule 59. It goes to Rule 64. 64.2. A member who desires to move a motion of this nature in writing should, if I may read it, a member desiring to move the motion under sub-rule 1, because it's a special motions, that's adjournment of adjournment motion, definite matter of urgent public importance. A member desiring to move the adjournment motion under sub-rule 1 shall, save in exceptional circumstances, given out to the satisfaction of the Speaker.
Sir, Ssemujju and others versus the Attorney General, 2004. Malik Mabirizi versus the Attorney General, 2021. Crystal clear, Mr. Speaker, sir. We're not going to allow a total constitutional breakdown happening on our watch. I'm going to partner with my honorable colleague, Honorable Ssemujju. that is either that matter considered tomorrow or no matter. So my procedural issue, Mr. Speaker, sir, is having taken the oath, the constitutional oath, would we, Mr. Speaker, sir, be proceeding correctly while we see the executive undermining the very oath, because the ruling of the Supreme Court is non-negotiable? What I don't want, Mr. Speaker, is I don't want your leadership in this House to be co-opted in illegality and also criminality as it relates to offending Article 92 of our Constitution, which is crystal clear. Thank you, Mr. Speaker.
Thank you. Watkins, my brother, here, we don't have powers of enforcement of court orders outside those directed at our institution. We can only comment. We can only comment, and that's why around all this much time, and I ask, we can only put the Attorney General and government task to update us. But when it comes court orders, we cannot come here and we give orders. We can't. These are matters of court, settled, okay? Attorney General and the team government, they know what they are supposed to do. Now, in case they don't do what they are supposed to do, okay, the other parties who are aggrieved can go to court for contempt. And I think one of the colleagues, I don't know who raised it, said, Mr. Byabashija, if we go to court to start proceedings against it, was Honorable Sachkuba, I think, for contempt. Honorable Nwagawa, yes, for contempt of court. So here, on such a matters, Parliament was not party. We can only comment. And even with our comments, we cannot start taking sides because court already made a decision. So, colleagues, I request you, I beseech your indulgence, that let us know where our powers stop and we remain playing within the boundaries of our powers as an institution.
Thank you so much, Right Honourable Speaker. Right Honourable Speaker, there is a matter on agriculture insurance that is being referred to a minister to bring a response next Thursday. And close to a year back, I raised a question again on insurance, and the Attorney General asked for time to get information, and he has never gotten back to us. Would it be procedure right that on the same Thursday, he responds to a question that I asked here, where banks charge double insurance over top-up loans?
Honorable Attorney General.
Right Honourable Speaker, I do not recall undertaking to report back about double insurance of banks, because that's really way outside my realm of, I wouldn't have undertaken that. I think, but if you want me to go and research on it, I can do it, but definitely.
No, it's Minister of Finance.
It's Minister of Finance,
yeah,
maybe. I don't know anything about insurance and their double charges.
Just let me make it very easy for you, Honorable Aisha. I put it in writing, okay? Submit it, I'll ensure the Minister of Finance.
Right, Honourable Speaker, it's a question I've asked twice. That will be the third time. The last time I asked that question, it was addressed to the Prime Minister. The Prime Minister addressed the matter to the Attorney General. The Attorney General said, let me go consult and I come back.
Can I request, raise the matter now, okay? The way you wanted it, and I refer it to the right minister.
Thank you so much, Right Honourable Speaker. Right Honourable Speaker, when people go to get loans from banks, especially when they're getting top-up, okay, ordinarily banks charge for insurance on every loan. When you go to get a top-up loan, again, insurance is charged. But when they are charging that insurance, they charge for the whole loan. Let me give an example. If you are left with a balance of a loan of 40 million shillings and you want to top up 100 and they're only going to give 60 million, they charge insurance on the whole amount of loan, which is double charging, because the portion that is you're not taking would be paid for already. So it is cheating people, charging them twice over money that is not taken. So my question was, is it fair, and why isn't government doing regulations that will guide banks not to charge people twice over top-up loans? Thank you.
Thank you, Minister for Finance. That's the regulator.
Right Honorable Speaker and colleagues, if I have understood Honorable Aisha well, this is the matter between commercial banks and their clients.
They're asking a regulator. As a regulator.
We don't, Mr. Speaker, we don't negotiate on behalf of the clients. Take the loan or don't take. If the loan is bad, leave it.
Senior banker, you wanted to say something? Honorable Mara? Honorable Msasizi, you usually give us answers. Today I don't know who has disturbed you. You rarely give such answers. Honorable Mara?
Thank you very much, Right Honorable Speaker. The practice is always that every loan that we get from the bank, whether personal loans or vehicle loans or home loans, normally carries some component of insurance charges. And so it will run down for a period of time as agreed by the client. But if you have exhausted, let me say you borrowed a 2-year loan and you're finished 1 year and you want a top-up, normally that top-up will come with an insurance charge again. And it is a relationship, it's an arrangement, it's a product arrangements between you and the bank. Bank of Uganda or the Ministry of Finance has nothing to do with it. Now, if there is any disagreement, because what Bank of Uganda does is to make sure by regulation, all banks must display all their charges in the public so that the people can see, they can educate them. But if you choose to take a particular product, it would have been believed that you've taken it from a point of knowledge. So they should explain thoroughly to you about the products, benefits, and the charges that come with it. So I don't think it's something that the Ministry of Finance would get involved in, or even the regulator.
Now,